We're here this morning with my colleagues Deanne Mazzocchi and Grant Worley as the three Republican members of the Special Investigative Committee that was brought forward to investigate a charge against Speaker Madigan. As you recall, this past summer, the United States Attorney's Office and Commonwealth Edison entered a deferred prosecution agreement in which ComEd admitted to, over the course of a decade, taking a series of actions to reward and influence public official A. Public official A was identified as Speaker of the House Mike Madigan, and he was named in the deferred prosecution agreement 72 times. This obviously caught significant attention from both Republicans and Democrats all across the state of Illinois. And on August 31st, Leader Durkin, along with two other members of the House, followed House rules and entered a petition to form a special investigative committee to better understand what Speaker Madigan's involvement was with the actions that were laid out in federal court, and to get to the bottom of the truth of what happened. The Special Investigative Committee was established. There were 3 Republicans and 3 Democrats appointed, and the Special Investigative Committee scheduled its first meeting. Unfortunately, here we are today, 71 days after the petition was first filed, and the Special Investigative Committee has only met twice. We've only heard from one witness, one voluntary witness. The chairman of the committee, Representative Chris Welch, has blocked attempts to use the power of subpoena that the committee has to call in other witnesses, including Speaker Madigan and the many others who are named in the deferred prosecution agreement, who we know have relevant and important information that is necessary for our committee to conduct its investigation in a thorough, complete, and fair way. Frankly, it's shocking that the committee that's supposed to be conducting an investigation hasn't met in 42 days. There's no meeting scheduled for the foreseeable future. And the chairman has repeatedly pushed back against efforts by members of the committee and pushed back against the public comments of, again, both Republicans and Democrats calling on the committee to conduct a thorough investigation so members of the House of Representatives and the people of Illinois can have confidence that individuals who are elected to serve the people are being held accountable regardless of their position, and that there's not special treatment or special privileges given to a member simply because of their rank within the House of Representatives. This is a serious undertaking we have. It's a serious job to conduct this investigation. It does not happen frequently. It's only happened one time before in the history of the Illinois House, and we take that responsibility very seriously. However, individuals should simply ask themselves if, after 71 days, a committee that has only met twice, has only heard from one witness, and which has no meetings scheduled for the foreseeable future, is really conducting a fair and impartial investigation, or whether there are other factors at play. With that, I will turn it over to my colleague, Representative Deanne Mazzocchi.
Thank you, Leader Demmer. Good morning, everyone. Deanne Mazzocchi from Elmhurst, Illinois State Representative for the 47th House District. This committee under Chairman Welch is now littered with broken promises, and his decision to delay any further meetings is quite troubling. In September, Chairman Welch initially promised weekly meetings to get our committee work moving forward. It's November, and the committee has only met twice. The first meeting was procedural in nature. Chairman Welch halted everything ostensibly to wait on the U.S. Attorney, and then the U.S. Attorney gave us the go-ahead to call witnesses and seek documents. At the second meeting, we heard bombshell after bombshell from ComEd executives, giving a very detailed account of the company's role in rewarding and bribing public official A, Mike Madigan, by giving sweetheart contracts and no-show lobbying jobs to closely connected allies of the Speaker. Chairman Welch then broke his promise to keep going. He shut our work down, but he did promise he would start up November 5th after the election. Well, the election is over, and he showed that his promise was a rope-a-dope. He's delaying again. We're supposed to be investigating whether Speaker Madigan has acted in a manner unbecoming a legislator. I have never seen 3 Democratic members of an investigating committee so utterly disinterested in actually investigating. Our charge as a committee, as we have identified it, is to determine whether Speaker Madigan has committed a breach of the public trust. He was named 72 times in a deferred prosecution agreement entered into by ComEd. Mike Madigan gave a very weak excuse in a letter. It was not under oath, and we've already gathered evidence that contradicts or undermines his letter explanation. That's a problem when we're talking about conduct on becoming a legislator. The standard for being an honest legislator shouldn't be you haven't yet been found guilty in a criminal court of law. Mike Madigan owes the people of Illinois a higher standard than that, and many of his own Democratic House members have said they want a higher standard than that. Again, Mike Madigan has given his position in an undated September 25th, 2020 letter. That letter is not under oath, but the statements he made in it should be. One witness has already contradicted Speaker Madigan's version of events. There may be more, and that's why we need more witness interviews, and again, under oath. Chairman Welch has said he wants to wait for ComEd to give documents, but one of the critical documents that ComEd identified to date is an email from the Speaker's office manager forwarding Juan Ochoa's resume to ComEd, saying the Speaker wants to make sure you see this. Why wait to get that from ComEd, Chairman Welch? Why not just ask the Speaker to provide it to our committee or issue a subpoena for it so we can get moving? Welch isn't asking for it because the testimony that ComEd gave was false. He isn't asking for it because he knows the testimony ComEd gave was true. Squelching these meetings will not end the public's curiosity. It will not end my curiosity or other legislators' curiosity that's coming from both sides of the aisle. And it certainly does nothing to stifle the curiosity of the U.S. Attorney for the Northern District of Illinois as the investigation into sprawling corruption throughout state government continues. Chairman Welch, time is running out in this particular General Assembly to finish our work. It's no longer political. The election is over. We cannot let the work of this committee languish like the Ethics Committee and so many other blue ribbon panels that this House has created before. The stakes are too high this time, and it's time that everybody stood up to fight for the truth. At this time, I'd like to turn the floor over to State Representative Grant Worley.
Good morning. I'm State Representative Grant Worley. I represent the 41st District, Naperville, Warrenville, and both DuPage and Will counties. Why are we here today? It's really quite simple. Chairman Welch, we want the political games that you and your colleagues on this SIC are playing to stop. In the past, you have falsely claimed that it is us, the Republicans, who are playing politics with this process. In reality, it is you, Natalie Manley, and Liz Hernandez that are playing politics with this. We all know why, but I'd like to reiterate those reasons why you're doing this for all to understand. First and foremost, it's about power. Chairman Welch, you're drunk with power on this one. It is time to do the right thing for the people, the residents of Illinois. It's also about money. If you look at the campaign accounts of these three individuals serving on this SIC, the Special Investigations Committee, you'll see that they are flush with cash. Natalie Manley is sitting on $1.4 million that was gotten to her through the Speaker. It's also about jobs. If you look at who is employed within state government, you'll see that Liz Hernandez, who was part of the Metra scandal, her husband works for the House. Chris Welch is on record as trying to get his wife a job, a state job, and his mother a state job. So this gang of three is doing whatever they can to protect the Speaker because it in turn directly benefits them. Stop playing politics. Do what's right for the people of this great state of Illinois. Three leaders of the Democratic Party just this week or this past week called on the Speaker to step down from at least chairman of their party. Governor Pritzker, both of our senators, Senator Durbin and Senator Duckworth. Senator Duckworth went a step farther and said that the Speaker should step down from serving as Speaker of the Illinois House. I could not agree more with those three. As we've come to see, history repeats itself in the fact that the Speaker is nothing but defiant, as he usually is. But this committee is supposed to be above being a protection racket for the Speaker. The Special Investigating Committee has only been convened in extremely rare cases that warrant serious investigation of the behavior of a member of the House of Representatives. We enter into these proceedings seriously and soberly. We do not take the joy of seeing corruption in government. We simply want to clean out corruption in government. This week, several top Democrats, as I mentioned, recognized that the Speaker Madigan's record of unethical behavior and his fostering of culture of corruption in Illinois is an anchor that is dragging down their party. Just yesterday, we had another sitting member of the Illinois House say that he's not going to vote for Mike J. Madigan as Speaker. His continued leadership, both at the head of their state party and also in the Illinois House, erodes the public trust in this great body. We need to do whatever we can to get the public's trust back. To Democrats, the most important thing is winning elections, because they all wait until after the election in order to make these statements. If they truly want to do the right thing, which I'm glad they're finally here now, this should have been going on forever. It never should have been allowed to happen, but here we are. The election is over. Let's do the right thing. A new General Assembly is coming in soon. Let's get back to work. Let's get the Special Investigations Committee so we can start to work and rebuild that trust in the public process in the great state of Illinois. With that, I would like to turn it over to our counsel, Ron Safer.
Thank you. Good morning. My name is Ron Safer from Riley Safer Homes in Cancilla. I am counsel to both the petitioner, Leader Durkin, and the Republican members of this investigative committee. The committee is, as it's stated, an investigative committee. I have had the privilege of investigating, matters related to criminal conduct in the Northern District of Illinois for over 10 years as an assistant U.S. attorney. You cannot investigate matters related to criminal activity by inviting people to come forward and speak with you about it. You must subpoena them. If in the Northern District of Illinois, the U.S. Attorney's Office invited witnesses to appear in front of a grand jury instead of subpoenaing them, it would be a lonely exercise. The Speaker has, as indicated, in essence, testified before this committee, or attempted to, by submitting a letter that said what his position was and why he said he could not appear before the committee. Specifically, he said the federal investigation is more important than political theatrics, and I cannot in good conscience take any action that may in any way interfere with a federal investigation or potential prosecutions. First of all, it strains credulity that the Speaker is concerned with the health and welfare of the criminal investigation into his conduct. But even if you take that at face value, after that letter was written, John Lausch, the United States Attorney for the Northern District of Illinois, confirmed once again that the Speaker's testimony before this committee would not interfere with their criminal investigation. There is no excuse for the Speaker not to appear before this committee. The United States Attorney has made it clear 3 times, once orally and twice in writing, that he understands that this committee has a job to do, that he respects the committee's need to investigate this conduct, which, although related to criminal conduct and related to the criminal investigation, is of course guided by a different standard, and that is that it is conduct unbecoming to a legislator, certainly significantly below the bar of criminal misconduct. Nonetheless, the U.S. Attorney has made it very clear that the Speaker can testify before this committee, the committee can do its work, and that it will not interfere with the federal investigation. What Speaker Madigan is doing is trying to enforce 2 different rules, sets of rules, one for everybody else and one for himself. The first time this committee entertained this kind of a charge, the fact is that it took into account the assertion of the 5th Amendment by the subject of that investigation. Speaker Madigan, although he says he is not invoking the 5th, his failure to appear before this committee should similarly be held against him and all inferences drawn against him. Those are the rules They should be applied consistently. Thank you.
Thank you. Thanks to all of you. Okay, lots of questions in, so we'll try to get through all of them. Start with Dave Dahl at WTAX. As a super minority party, what leverage do you have over the speaker?
I'll answer. So this is the process we have against the speaker or any member of the House who commits a breach of the public trust or engages in conduct unbecoming a legislator. This is following the House rules, the establishment of a special investigative committee, and the exploration of any discipline against that member. This is kind of the point that we're making here, is that the Speaker of the House should be treated as any other member of the House of Representatives would be when these charges are brought, and we should move expeditiously through an investigation and conduct a thorough investigation to make a recommendation.
Greg Bishop at the Center Square. Any confidence this process will be completed before the new General Assembly is seated? What is the likelihood of having a hearing when the General Assembly comes back next week?
Yeah, I'll answer that. There's certainly we certainly have the ability to get the work done. The question is whether Chairman Welch has the will to get the committee's work done. I think if we were to, immediately swing into action and start getting things moving, we could absolutely get this done probably before Christmas time. It's just a question of will Chris Welch actually allow us to do the work?
From Jim Leach at WMAY, are there concerns about meeting in person in Springfield amid the surge in COVID cases?
I think that what we showed the last time we were able to have the General Assembly meet down in Springfield is everyone took appropriate precautions, and to my knowledge, there was not any instance where someone caught COVID as a consequence of us going down to do the work of the General Assembly. So I think there's certainly opportunities we can all take to do things correctly. But when it comes to the hearing and the committee members, again, we've taken appropriate steps where we can, be cautious, be safe, and certainly not have any risk above any other activity that's out there.
Two questions from Mark Maxwell. We'll start with the first one. What happens if a motion to file a subpoena ends in a partisan tie? Without any witnesses, would this be a dead end?
Yeah, and the answer to that is no. There are additional procedural tools that we have available, but it would really be a shame if we actually had to go exercise them. But again, I want to emphasize the point that under the House rules, particularly when this investigative file gets turned over to the committee that's actually going to make decisions and findings based on this, is that if in fact a subpoena is issued and people refuse to come forward and testify, then adverse inferences can be made against both the speaker as well as any witnesses who decline to come forward to testify. So that is why if in fact the speaker or these witnesses do have exculpatory information, they should be quite eager to come forward and share it with the committee, because if they don't, then under Mike Madigan's own House rules, those facts and his refusal to come forward and testify can and should be used against him when it gets to the next stage of the process.
The second question for Rep. Mazzocchi, and I think Ron, you might be able to chime in here too afterwards. Can Representative Mazzocchi clarify what specifically the witness said that contradicts Madigan's letter?
Sure. So for example, one of the things that Speaker Madigan stated in his September 20th letter, I believe, September 25th letter, I believe it's the fifth full paragraph down. He said that he only purportedly made recommendations in connection with hiring. Again, the ComEd witness testimony made very clear that when it came to Juan Ochoa and the board seat, that there were specific instances where an email was sent from Speaker Madigan's office manager to ComEd, encouraging them to take a look at Juan Ochoa's resume for purposes of hiring. So, the idea that the speaker says that these were quote unquote purported recommendations being made by him or on his behalf is certainly contradicted by the ComEd testimony. Similarly, if you were to look at the plea agreement involving Fidel Marquez, one of the things that the speaker says in his letter is that, if individuals, and by implication referring to Mike McLean, were making deals or were suggesting that there would be a quid pro quo favor on his behalf, that's certainly not something that he was aware of. Yet, if you look at the Marquez plea agreement, I believe it's in around page 5, Marquez made clear that it was his understanding that individual one, who I believe is Mike McLean, was in fact communicating on behalf of public official A. So here again, we have a whole host of evidence that is contradictory to the speaker's claims made in his letter. And this is why, again, I think it's very important that we get all of these individuals in front of the committee so that we can get testimony clear on the record as to what did or didn't go on.
I would simply add that the entire, excuse me, the entire scenario that was portrayed in the speaker's letter has been contradicted by the Commonwealth Edison testimony. What the speaker, in essence, says is he recommended certain isolated individuals for jobs and that is just fine. And that is just fine. But the testimony of the Commonwealth Edison and the deferred prosecution agreement paints an entirely different picture, which is a pattern of the speaker having people be hired by Commonwealth Edison and Commonwealth Edison doing that in an attempt to influence the speaker's activities as a legislator. And the witness made it very clear that that was Commonwealth Edison's intent. And it is a scenario that is totally different than that portrayed by the speaker's letter. In addition, it was very clear that the speaker had Commonwealth Edison put a member of the board of directors in place, and that they did so in an attempt to influence Speaker Madigan in the performance of his activities as a legislator. That's not recommending an individual for a job.
Thank you. From Mike Militich, what do you think of Fidel Marquez declining the invitation to testify before the committee? As someone who pleaded guilty to the bribery scheme, isn't his information critical to your investigation?
Sure, I think that his information is critical to the investigation. And again, I think that if you look at the terms of the statements that were made in his plea agreement itself, some of the critical pieces of information are in fact contained within that plea agreement. You know, one of the ones that I just mentioned where he admitted that it was his understanding that individual one, believed to be Mike McLean, was in fact communicating his desires on behalf of public official A, Speaker Madigan. So I think particularly when you take that piece of information and combine it with the various statements that that Mike McLean is believed to have stated that are recorded in the ComEd deferred prosecution agreement, that paints an extraordinarily bad picture when it comes to the speaker. So I think it certainly would be better for Fidel Marquez to come forward and tell his story. If the only thing we're left to, to look to are his plea agreement as well as the companion, testimony that he provided in court in connection with that plea allegation, so be it. But, here again, this is an area where I think it's incumbent on Chairman Welch to call us back in and say, okay, do you want these, statements that were made by Fidel Marquez to effectively be the findings as to his testimony? Or do you think that there's some clarifying information that might be exculpatory to the speaker, in which case you should bring him in and issue the subpoena. And then again, we can, cross that bridge when we get to it.
Even if Madigan and others are subpoenaed, they can decline to answer question. How does that advance the House investigation?
Sorry, again, this advances the House investigation because, as we noted previously, under Mike Madigan's own rules, if you are asked questions and decline to answer, whether it's because you're pleading the fifth or for some other reason, precisely because this is not a criminal court of law, this is a proceeding that relates to the House governing itself, those statements that you're declining to answer because the answer may incriminate you can actually be used to make adverse factual inferences by the committee that ultimately makes recommendations in connection with any discipline.
Mike Militich, Rep. Worley, you have consistently fought for ethics reform and called out Speaker Madigan. How would you feel if this committee doesn't finish its investigation before the next General Assembly?
So as I get ready to leave office in January 12th or whatever the date is, I know that when I first came in 2015, that I have done everything that I possibly can to raise the bar when it comes to ethical standards, that I've done everything that I could to root out corruption to this point. Look at where we were as a state, as a General Assembly in 2015 and to where we are now. Back then, people didn't even dare criticize the Speaker. And now here we are with the SIC going on that is exposing at its very core the corruption that is central to the man's very political existence. So would I like to see it done before I leave? Absolutely. But I also take great pride in knowing that I was a part of getting us to where we are. I think it was Voltaire that once said, to determine who rules over you, simply determine who cannot be criticized. And here we are, because of Profiles in Courage, of people finally stepping up and calling what they see and what's going on in Springfield. It's a new day in Springfield right now. I might not be around to see the new General Assembly complete this task, but I take great pride into getting us where we are now.
And then one last off-topic question actually for you, Representative Worley. Do you have any comment on the delays we're seeing in counting or reporting the count of mail-in ballots in your race? Do you feel as if there's a transparency issue if we don't see any significant results posted until November 17th?
I do. I think the county clerk here in DuPage County, we need to take a serious look at how we run our elections. Not only were there significant time delays in posting the results on election night, but the vote by mail process is someone that I have a raised eyebrow to. As part of my campaign, we sent a chase letter to everybody that requested or was sent a vote by mail ballot. Currently, I'm sitting on over 250 of those that were returned either undeliverable, address change, forwarding time expired, and yet it was through the county's data that we got the list of who actually was sent a ballot. So there are some concerns. I try to believe as much as I can in a fair and open election process here, but the delays certainly aren't helping, and we need to look at how we can at least get a more transparent VBM vote by mail program going on, especially here in DuPage County. We used to be the leaders in recognizing how we report elections, and now we're woefully lacking.
Thanks. Okay, and actually I just had one more question come in from Greg Bishop at the Center Square. What are those procedural actions to get a subpoena if deadlocked in the committee?
Stay tuned.
Please consider subscribing to our channel. And while you're at it, please leave us a comment. Thank you for watching.